A few days ago, a quiet legal proceeding in a Bristol High Court accidentally detonated a ticking time bomb directly under Montecito, California. While the world was distracted by the usual royal family drama, an aristocrat walked into a courtroom and admitted something extraordinary about his 9-year-old son. It was a confession that brought a 400-year-old law screaming into the modern era, and it asked a question that Buckingham Palace has been desperately tiptoeing around since 2019. If a £157 million aristocratic inheritance can be frozen over the definition of how a child was born, what happens to the line of succession for a 1,000-year-old crown? The Marquis of Bath didn't go to court to start a scandal. He went to protect his family. His second son, Henry, was born through a legally documented surrogacy in West Hollywood back in 2016. The Marquis has been completely transparent about this, showing a deep, obvious love for his child. But the British legal system didn't care about a father's love. The judge, Mr. Justice Matthews, looked at this biologically verified 9-year-old boy and stated plainly that there is serious uncertainty about whether he legally qualifies as an heir. Under the Peerage Act of 1963, a child not born of the body of the mother simply does not compute when it comes to inherited titles and estates. The law demands that the Marquis formally petition the court just to manually add his own son as a beneficiary. But that hyper-specific legal hurdle wasn't just a problem for one wealthy family in Bristol. It was the exact precedent that a certain couple in California had been praying would never see the light of day. Because the British royal family operates on the exact same ancient principle. The phrase "born of the body" isn't just a quaint aristocratic tradition. It is the absolute bedrock of the Act of Settlement of 1701. For 325 years, that specific phrase has ruthlessly governed who gets to sit on the throne. Every single royal heir born under that clause has been witnessed by palace-appointed officials, verified by independent doctors, and documented for the public record. There were no shortcuts, no exceptions, and absolutely no workarounds allowed. The system was airtight, designed specifically to prevent imposters or succession crises. That is, until the spring of 2019, when the entire royal rulebook was seemingly thrown out the nearest window. When William and Catherine welcomed their children, the entire process was a masterclass in constitutional transparency. George, Charlotte, and Louis were born at St. Mary's Hospital, their births verified by official royal doctors, and the proud parents stood on the hospital steps within hours for the entire world to see. It wasn't just about sharing their joy, it was about proving the legitimacy of the bloodline. But when Archie arrived on May 6, 2019, at London's Portland Hospital standard protocol vanished. There was no traditional photo call. There was no official notice signed by the attending physicians, a standard practice for every royal birth in living memory. Instead, Harry later wrote in his memoir that they slipped out via an underground car park in a people carrier arriving back at Frogmore Cottage before the palace press office had even confirmed labor had started. For an institution that spent 3 centuries making births a matter of public record, this sudden veil of absolute secrecy was jarring. The arrival of Lilibet in June 2021 only deepened the mystery. Born at Santa Barbara Cottage Hospital, the details were kept entirely under wraps until Harry released his memoir, Spare. He painted a highly dramatic picture describing electric candles, framed photos of Princess Diana, and an Ayurvedic doctor advising them to whisper wishes to the baby in its first 60 seconds. He even claimed he literally delivered the baby himself, sliding his hands under her neck to pull her into the world. It's a beautifully written, poetic image. But constitutional legitimacy doesn't run on poetry. Unlike every significant royal birth since the early 1700s, neither of these arrivals was independently witnessed by palace-appointed officials. There was no Privy Council notification in the traditional form. When your children sit 6th and 7th in line to the British throne, a beautifully written chapter in a memoir isn't a substitute for a legal medical document. And that lack of documentation allowed long, simmering whispers to turn into a deafening roar. Speculation about the pregnancies had been brewing for years, fueled heavily by early warnings from Samantha Markle. At the time, she was dismissed by many as just a bitter sister looking for a headline. but she explicitly told the public to look closely at the timelines and the history. Rumors began surfacing referencing Meghan's first marriage to Trevor Engelson, with unverified claims circulating about past medical procedures that would make carrying a child incredibly difficult, if not impossible. In the United Kingdom, surrogacy laws are strict. The child legally belongs to the surrogate upon birth, regardless of biology. In places like California, however, the laws are entirely different, making it a global destination for private surrogacy arrangements. When you combine those geographical choices with the absolute refusal to produce standard royal medical signatures, the public didn't just have questions, they had a timeline that suddenly seemed to make a lot of uncomfortable sense. Prince William, according to multiple well-placed palace insiders, is entirely aware of how this looks. The future king didn't create this constitutional headache, but he is the one who will eventually inherit it. Sources suggest William finds the circumstances surrounding the Sussex children to be highly suspicious, and his recent actions speak far louder than any official palace statement ever could. He has systematically moved to distance the Sussex brand from the monarchy's core identity. Profiles have been quietly scrubbed or downgraded on the royal website, and titles are kept under constant review for commercial exploitation. William knows that a monarchy built on bloodlines can survive a lot of things. It can survive divorces, public scandals, and even a rogue prince airing his family's dirty laundry on television. But the one thing it absolutely cannot survive is a legitimate legal doubt about who is actually qualified to wear the crown. This brings us to the ultimate glaring hypocrisy of the entire situation. The Marquis of Bath is fighting for his son in open court. He is embracing full transparency and full accountability, willing to face the archaic laws head-on to secure his child's future. In stark contrast, Montecito operates entirely in the shadows. When questions are asked, the public doesn't get a simple, straightforward verification that would put the rumors to bed forever. Instead, they get PR spin aggressive legal threats and cease and desist letters sent to anyone who dares to ask for basic constitutional clarity. It leaves the world wondering if there is truly nothing to hide. Why does the simplest question in royal history require the most aggressively complicated response? But to truly understand why this Bristol court case is sending shockwaves all the way to California, we have to stop looking at the gossip and start looking at the map. The geography of where these children were born isn't just a background detail. It is the entire legal strategy. You have to ask yourself why a couple so desperate for security status and royal perks would choose the United States for their growing family. The answer lies buried in the rigid, unbending rules of the United Kingdom. Under British law, surrogacy is highly regulated. The woman who physically delivers the child is legally recognized as the mother, full stop. It does not matter whose DNA is involved. The birth mother holds the cards, and commercial surrogacy paying someone to carry a child is strictly illegal. Now look across the Atlantic to California. West Hollywood and Santa Barbara aren't just sunny retreats for celebrities, they are global epicenters for legally ironclad commercial surrogacy contracts. In California, the biological parents can secure pre-birth orders sealing the legal parentage before the baby even takes its first breath. The surrogate's name never has to appear on the public birth certificate, and the paperwork can be locked away behind aggressive privacy laws. When you put the strict, unforgiving UK laws next to the hyper-private, commercially friendly California laws, the sudden transatlantic flight to secure their family's future starts to look a lot less like a quest for freedom and a lot more like a calculated search for a legal loophole. And the whispers about why they might need that loophole didn't just appear out of thin air. They trace all the way back to Meghan's past. Long before the royal wedding, deeply buried rumors were already circulating among those who knew her during her first marriage to producer Trevor Engelson. According to sources and journalists who have dug into her early Hollywood years, there were ongoing discussions regarding undisclosed medical procedures. Procedures that would allegedly make carrying a child to term incredibly difficult, if not biologically impossible. Being a mother later in life brings its own set of intense medical hurdles. But when you combine the geriatric mother label with persistent, unverified claims of past surgeries, the absolute refusal to allow traditional royal doctors anywhere near the delivery room suddenly takes on a much darker, more secretive tone. Let's rewind to the birth of Archie at London's Portland Hospital on May 6, 2019, because the timeline they provided the public doesn't just bend the truth. It practically shatters medical reality. For decades, royal protocol dictated a massive coordinated operation. The Home Secretary historically had to be present to verify royal births, a tradition that evolved into having trusted palace-appointed physicians sign a public notice. Meghan categorically refused the hospital traditionally used by the royals, and she locked out the normal medical staff. That alone raised eyebrows. But then Harry published his memoir Spare and accidentally gave the public a timeline that left medical professionals completely baffled. In his own words, Harry described a highly dramatic birth scene. He claimed Meghan required not one, but 2 epidurals. Any doctor or mother will tell you that a double epidural is a significant medical event requiring intense observation and careful recovery. Yet in the very same chapter, Harry writes that they were out of the hospital within 2 hours. 2 hours. According to his account, they slipped into an elevator, snuck into an underground car park, hopped into a people carrier, and vanished back to Frogmore Cottage before the palace press office had even confirmed that Meghan was in labor. Leaving a hospital 2 hours after a double epidural isn't just unusual. For a high-profile figure carrying the 6th in line to the throne, it borders on medical fiction. And the bizarre details didn't stop there. For a family whose entire existence justifies itself through constitutional legitimacy, the Sussexes treated the arrival of an heir like a wellness retreat. Harry's book describes an atmosphere filled with electric candles, framed photos of Princess Diana strategically placed around the room, and an Ayurvedic doctor advising them to whisper secret wishes to the baby within its first 60 seconds of life. It reads exactly like a lifestyle article from a trendy Hollywood magazine, completely disconnected from the heavy documented legally binding reality of a British royal birth. As one sharp critic pointed out online, the rest of the royal family gives the nation a certified birth announcement. Harry gave the world a scented candle inventory. By the time Lilibet arrived in June 2021, the Sussexes didn't even bother pretending to follow the rules. Born at a hospital in Santa Barbara, her birth was shrouded in total, absolute lockdown. Harry's description of this event in Spare escalated from bizarre to almost unbelievable. He claimed that he literally delivered the baby himself, writing about sliding his hands under her tiny back and pulling her from that world into this one. It's a beautifully crafted sentence clearly designed to pull at the heartstrings. If it's entirely true, it's a deeply personal, beautiful moment for a father. But here is the cold, hard constitutional reality that the Sussex PR machine refuses to acknowledge. A beautifully written paragraph in a controversial memoir is not a legally binding document. Not a single independent palace-appointed official witnessed Lilibet's arrival. There was no traditional notification to the Privy Council. There was only Harry's word. And when the stakes involve the ancient line of succession to the British throne, a prince's word, especially a prince who has publicly admitted to heavy substance use and memory issues in his own book, is simply not enough to satisfy the law. This brings us to the agonizing silence of King Charles. Why hasn't the king acted? Why hasn't he demanded proof, stripped the titles, and ended this circus once and for all? Palace insiders suggest Charles is trapped in a paralyzing web of family guilt and institutional fear. With the ongoing, deeply damaging scandals surrounding his brother, Prince Andrew Charles is reportedly terrified of opening another massive, catastrophic investigation into his own family. He is trying to keep the peace, hoping the Sussex problem will naturally fade away. But Prince William is playing an entirely different game. William isn't looking at the next 6 months, he is looking at the next 60 years. He knows that his reign cannot be built on a foundation of unanswered questions and hidden medical records. William understands that the crown cannot survive a crisis of legitimacy. According to multiple well-placed sources, William finds the entire timeline of both Sussex births incredibly fishy. He has reportedly drawn a hard line in the sand, systematically moving to erase the Sussex brand from the working machinery of the monarchy. If you look closely at the royal website today, the Sussex profiles have been quietly scrubbed, downgraded, and pushed to the absolute bottom of the page. William is isolating the contagion, because the hypocrisy coming out of Montecito is what truly drives the public crazy. It's not just the tabloid gossip or the endless stream of Netflix documentaries complaining about their hard lives. It's the fact that Meghan Markle simultaneously rejects the institution of the monarchy while aggressively clinging to its credentials. You cannot go on global television, accuse the royal family of the most horrific, unforgivable things, and then turn around and slap the title Duchess of Sussex on a jar of strawberry jam to make a profit. It is brand management wearing a tiara. She wants all of the global prestige, the VIP treatment, and the multi-million-dollar deals that come with a royal identity, but she outright refuses to do the grueling, unglamorous public service that pays for it. And this is where the silence from Montecito becomes their loudest confession. If they have absolutely nothing to hide, if Meghan carried both children naturally, without any external medical assistance or surrogacy, the solution is painfully simple. A single, independent DNA swab, a verified, undeniable release of the actual delivery room medical records, signed by attending non-NDA-bound physicians. A family that employs an army of lawyers who will instantly sue a newspaper for printing a private letter somehow cannot find the time to issue a simple factual medical verification that would silence their critics forever. Why does the simplest question in royal history require the most complex, threatening legal response? Every day that passes without that proof is another day that Samantha Markle looks less like a bitter sister and more like a prophet. Years ago, when Samantha first raised the alarm about the timelines, the sudden geographical shifts, and the medical impossibilities the media wrote her off, they called her jealous. They painted her as a villain in Meghan's fairy tale. But today, with a high court in Bristol openly debating the legal definition of born of the body, Samantha's warnings are no longer just internet gossip. They are constitutional arithmetic. We are watching a collision course between a 1,000-year-old monarchy and a modern Hollywood PR machine. The Marquis of Bath proved that the old laws still have absolute power over inherited wealth and titles. If an aristocrat has to beg a judge to recognize his surrogate-born son for a £157 million estate, imagine the legal apocalypse waiting for the British Parliament if undeniable proof ever leaks about Archie or Lilibet. Parliament would be forced to invoke the Succession to the Crown Act. They would have to formally publicly investigate the Sussex children, potentially altering the line of succession on the floor of the House of Commons. It would be the greatest constitutional crisis since the abdication of King Edward VIII. Harry and Meghan thought they could rewrite the rules of the oldest institution on Earth and hide the evidence behind California privacy laws. But history, tradition, and the British legal system have a very long memory. The trap wasn't set by Buckingham Palace. The Sussexes set it themselves the moment they decided they could outsmart a 400-year-old law. The truth is coming, and no amount of celebrity PR, expensive lawyers, or Netflix specials will be able to stop it when the dam finally breaks. If you thought the details of this legal loophole were shocking, the actual timeline of what happened behind closed doors in the spring of 2019 is going to change everything you thought you knew about this couple. I'm connecting dots in the next video that even the most hardcore royal insiders have missed. Make sure you're subscribed and turn on notifications, because when that video drops, the entire narrative is going to flip and you will need the context.